The department's collection effort resulted in more than 6 million pages being identified as potentially responsive, including department and FBI emails, interview summaries, images, videos, and various other materials collected and generated during the various investigations and prosecutions that the Act covered. We erred on the side of over-collection of materials from various sources to best ensure maximum transparency and compliance, which necessarily means that the number of responsive pages is significantly smaller than the total number of pages initially collected. That's why I mentioned a moment ago we're releasing more than 3 million pages today and not the 6 million pages that we collected.
The Trump administration just dumped 3 million documents related to Jeffrey Epstein on Friday, and they're hoping you'll be so overwhelmed by the sheer volume that you won't notice what's missing. But here's what they're not telling you. There are 3 million more documents that they're refusing to release. That's right. Half of the Epstein files are still being concealed by the Trump Department of Justice, hidden behind what legal experts are calling fraudulent privilege claims that directly violate federal law. And the documents they're hiding, those are likely the most damaging, the most significant, and the most politically explosive materials in the entire archive. This isn't transparency. This is a cover-up disguised as disclosure. The Trump DOJ is counting on the American people to see the headline, "Trump releases Epstein files," and move on, assuming the story is over and everything has been revealed. But that couldn't be further from the truth. In court filings submitted to 2 federal judges this week, Judge Annalisa Torres and Judge Lewis Kaplan, Trump's DOJ openly admitted that they would be withholding substantial portions of the Epstein files based on claims of deliberative process privilege, attorney-client privilege, work product privilege, and executive privilege. These are legal mechanisms designed to protect sensitive government communications, not to hide evidence of potential crimes or protect powerful people from scrutiny. And here's the kicker. The Epstein Transparency Act, the actual federal law that mandates the release of these files, does not permit the withholding of documents based on privilege claims. The law is crystal clear. It requires the production of every single document in the Epstein files, with only one exception: redactions to protect the identities of victims and survivors. That's it. No executive privilege loopholes. No attorney-client exceptions, no deliberative process exemptions. Just release the files and protect the victims. But the Trump administration is flagrantly violating that law, and they're betting that most people won't notice or won't understand the legal sleight of hand they're pulling. Let me explain exactly what the Trump administration did on Friday, because the details matter and the deception is in those details. The Epstein Transparency Act was passed by Congress and signed into law specifically to ensure full public disclosure of all government documents related to Jeffrey Epstein, his criminal activities, his associates, and any government knowledge of or involvement in his sex trafficking operation. The law was a response to years of public outcry, demanding answers about how Epstein operated for so long, who protected him, who was involved with him, and what the government knew. The law is straightforward. It mandates that federal agencies produce all documents related to Epstein. The only permitted redactions are for victim protection, names, photos, identifying information of survivors who were trafficked and abused. The purpose is to get the truth out while protecting the people who were harmed. On Friday, the Trump Department of Justice announced that they were complying with the Epstein Transparency Act by releasing approximately 3 million documents. That sounds like a lot. The media ran with headlines about the massive document dump. Trump's supporters celebrated it as proof of his commitment to transparency. But here's what those headlines didn't tell you. The Trump DOJ had approximately 6 million documents in total related to Epstein, and they only released half of them. 3 million documents are still being withheld. And according to court filings submitted earlier this week to Federal Judge Annalisa Torres in the Southern District of New York and Federal Judge Lewis Kaplan in related litigation, the Trump DOJ explicitly stated that they would be withholding documents based on various privilege claims. They didn't specify exactly how many documents would be withheld or what specific information those documents contain, but they made clear that substantial portions of the Epstein files would remain secret. The privileges they're claiming are deliberative process privilege, attorney-client privilege, work product privilege, and executive privilege. Let me translate what each of these means, because understanding the legal justifications is crucial to understanding why this is such a brazen violation of the law. Deliberative process privilege is supposed to protect internal government discussions about policy decisions, the idea being that government officials need to be able to debate options candidly without those discussions becoming public. Attorney-client privilege protects confidential communications between lawyers and their clients. Work product privilege protects materials prepared by attorneys in anticipation of litigation. Executive privilege protects certain communications involving the president and his advisors. Now here's the problem. None of these privileges are supposed to apply when there's a federal law explicitly requiring disclosure. The Epstein Transparency Act supersedes these privilege claims. Congress specifically passed a law saying, release these files. And when Congress passes a law mandating disclosure, executive branch privilege claims don't override that law. Here's where this gets serious, and I need everyone to understand why the Trump administration's selective release of the Epstein files is both legally dubious and politically explosive. First, the Epstein Transparency Act doesn't have a privilege exception. Go read the law yourself. It's public. The law requires federal agencies to review and disclose all records related to Jeffrey Epstein. The only authorized redactions are for victim protection. There is no clause that says, except for documents covered by executive privilege, or unless the Attorney General determines certain materials are privileged. The law is unambiguous. Release everything. Protect the victims. End of story. So when the Trump DOJ claims they can withhold 3 million documents based on privilege, they're making up an exception that doesn't exist in the law. They're asserting a power that Congress did not grant them. They're unilaterally deciding to ignore a federal statute, and they're doing it in a way that conveniently allows them to hide whatever documents they want to hide. Second, the timing of this release is deeply suspicious. The Trump administration waited until the last possible moment to comply with the Epstein Transparency Act. They've been in office for months, and they only produced documents after facing court deadlines and judicial pressure. And even then, they only produced half of what they have. This isn't the behavior of an administration committed to transparency. This is the behavior of an administration trying to run out the clock and limit what the public can see. And this is the part no one can ignore. The documents they're withholding are almost certainly the most significant documents in the entire collection. Think about it logically. If you were going to release documents to comply with the law but wanted to hide the most damaging material, you'd release the innocuous stuff, the administrative records, the already public materials, the documents that don't implicate powerful people, and you'd claim privilege over the explosive material. That's exactly what's happening here. The 3 million documents they released likely contain a lot of information that's already been reported, already been investigated, or doesn't involve living public figures in compromising situations. The 3 million documents they're hiding, those are the ones that powerful people don't want you to see. Those are the ones that could implicate government officials, political figures, business leaders, or celebrities. Those are the ones that could reveal who knew what and when about Epstein's crimes. Let's talk about the specific evidence of what the Trump administration is doing, because this isn't speculation. It's documented in federal court filings. Earlier this week, the Trump Department of Justice submitted filings to 2 federal judges, Judge Annalisa Torres and Judge Lewis Kaplan, both of whom are overseeing litigation related to Epstein and his associates. In those filings, the DOJ explicitly previewed that they would be withholding documents from the Epstein file release. The DOJ stated that pursuant to the Epstein Transparency Act, we will be withholding certain documents on the basis of privilege claims. They listed deliberative process privilege, attorney-client privilege, work product privilege, and executive privilege as the grounds for withholding materials. They indicated that they would produce some documents on a specified date, which turned out to be Friday, but that other documents would be withheld pending further review or indefinitely based on privilege. Now here's what's so outrageous about this. The Epstein Transparency Act doesn't authorize any of those privileges as grounds for withholding documents. The DOJ is citing legal doctrines that apply in normal FOIA litigation or discovery disputes, but the Epstein Transparency Act is not a normal disclosure statute. It's a specific congressional mandate that overrides typical privilege claims. When Congress passes a law requiring disclosure of specific documents, that law takes precedence over executive branch assertions of privilege unless the law itself creates exceptions for privilege, which the Epstein Transparency Act does not. The only exception in the law is for victim protection. Everything else must be disclosed. Legal experts who have reviewed the Epstein Transparency Act have been clear about this. The law does not contain a deliberative process exception. It does not contain an attorney-client privilege exception. It does not contain an executive privilege exception. Those are privileges that can be asserted in other contexts, but not in response to a congressionally mandated disclosure statute that doesn't recognize them. So what the Trump DOJ is doing is essentially inventing an exception to federal law. They're saying, we know the law requires us to release everything, but we're going to assert privileges anyway and withhold whatever we want. And they're betting that federal judges won't force them to comply, that Congress won't hold them accountable, and that the public won't understand the legal nuances well enough to realize they're being deceived. The court filings also reveal that the DOJ did not provide a specific inventory of what documents they're withholding or why. They didn't submit a privilege log, a detailed accounting of each withheld document, and the specific privilege justification for withholding it. That's standard practice in litigation when you're asserting privilege. You have to explain, document by document, why each item is privileged. The Trump DOJ hasn't done that. They've made blanket assertions about withholding documents without providing the transparency that would allow judges or the public to evaluate whether their privilege claims are legitimate. This exposes a much bigger problem because the Trump administration's handling of the Epstein files is part of a broader pattern of obstruction and concealment. First, consider who benefits from withholding these documents. Jeffrey Epstein had connections to powerful people across the political spectrum, in business, in entertainment, in academia. His trafficking operation involved elite circles. The documents being withheld likely contain information about those connections, who visited Epstein's properties, who flew on his planes, who was involved in his business dealings, who may have known about or participated in his crimes. Some of those people are Trump's allies. Some may be Trump's opponents. Some may be Trump himself or members of his family. We know from public reporting that Trump and Epstein were social acquaintances for years before Epstein's crimes became widely known. We know there are photos of them together at events. We know Trump has made comments about Epstein that suggest a closer relationship than Trump now admits to. So when the Trump administration withholds 3 million documents from the Epstein files, the obvious question is, who are they protecting? What's in those documents that's so damaging that they're willing to violate federal law to keep it hidden? Second, the Trump DOJ's privilege claims are legally dubious at best and fraudulent at worst. Deliberative process privilege is supposed to protect policy deliberations, discussions about what regulations to adopt, what enforcement priorities to pursue, what legislative positions to take. It's not supposed to protect evidence of crimes or cover up government misconduct. If the withheld documents contain evidence that government officials knew about Epstein's trafficking and failed to act, that's not a privileged policy deliberation. That's evidence of potential criminal negligence or obstruction. Attorney-client privilege is supposed to protect confidential legal advice, but if government lawyers were providing advice about how to cover up Epstein's crimes or how to protect people associated with Epstein, that's not legitimate attorney-client communication. That's potentially a crime-fraud exception situation where the privilege doesn't apply because the communications were in furtherance of illegal activity. Work product privilege protects litigation strategy materials. But the Epstein files aren't litigation work product. They're investigative records, law enforcement files, intelligence documents. Claiming work product privilege over historical investigative materials is a stretch that most judges wouldn't accept in normal circumstances. And executive privilege is the most abused privilege in government. It's supposed to protect the president's ability to receive candid advice from close advisors on matters of national security and policy. It's not supposed to hide embarrassing information or protect political allies from scrutiny. If the Trump administration is claiming executive privilege over Epstein-related documents, the question is, why would discussions about Jeffrey Epstein's sex trafficking operation involve presidential decision-making that requires confidentiality? The walls are closing in on the Trump administration's cover-up because federal judges are not likely to accept blanket privilege claims that violate a clear statutory mandate. Judge Torres and Judge Kaplan are experienced jurists who understand the law. If the Trump DOJ tries to withhold documents without proper legal justification, the judges can order disclosure. They can reject privilege claims. They can hold DOJ officials in contempt if they refuse to comply. But here's the problem. Judicial enforcement takes time. The Trump administration can drag out privilege disputes for months or years. They can appeal every adverse ruling. They can litigate over every document, and in the meantime, the documents remain hidden, the truth remains concealed, and the people who should be held accountable remain protected. Let me be absolutely clear about what's at stake in this fight over the Epstein files. Legally, the Trump administration is violating federal law. The Epstein Transparency Act requires disclosure of all documents with only victim protection redactions. The Trump DOJ is withholding 3 million documents based on privilege claims that the law doesn't authorize. This is not a gray area. This is not a reasonable interpretation of ambiguous statutory language. This is a deliberate decision to ignore what the law says because complying with the law would reveal information the administration wants to hide. If federal judges allow the Trump DOJ to get away with this, if they accept privilege claims that contradict the plain text of the Epstein Transparency Act, then the law becomes meaningless. Congress can pass all the transparency statutes it wants, but if the executive branch can simply claim privilege and withhold whatever it wants, those laws have no teeth. This is a fundamental separation of powers issue. Congress passed a law. The executive branch must comply. If the executive branch refuses to comply, the judiciary must enforce the law. Politically, this is a disaster for Trump's credibility on transparency and accountability. Trump has positioned himself as someone who will expose the deep state, drain the swamp, and reveal the truth about elite corruption. His supporters believe he's fighting against a corrupt establishment that protects its own. But when Trump's DOJ withholds half the Epstein files and uses the same legal privileges that establishment figures have always used to hide information, it exposes the hypocrisy. If Trump really wanted transparency about Epstein, he would release everything. He controls the Department of Justice. He controls the FBI. He controls the intelligence agencies that have Epstein-related files. He could order full disclosure tomorrow. The fact that he's not doing that, the fact that his DOJ is actively withholding documents in violation of federal law, tells you everything you need to know about what's really in those files. And here's what should concern everyone. If the withheld documents weren't damaging to Trump or his allies, there would be no reason to hide them. The Trump administration would happily release documents that implicate Democrats, never-Trumpers, media figures, or anyone else Trump views as an enemy. The fact that they're claiming privilege across the board suggests that the withheld documents contain information that would damage people the Trump administration wants to protect, and that could very well include Trump himself. The timeline is tightening, and the legal battle over the withheld Epstein documents is just beginning. Advocates for full transparency, including victims' rights groups, investigative journalists, and legal watchdog organizations, are already preparing to challenge the Trump DOJ's privilege claims in court. They'll file motions demanding that the DOJ produce a detailed privilege log explaining exactly which documents are being withheld and why. They'll argue that the Epstein Transparency Act doesn't permit the privileges the DOJ is claiming. They'll ask federal judges to conduct in-camera reviews, private judicial examinations of the withheld documents to determine if the privilege claims are legitimate. This process could take months. The Trump DOJ will fight every step of the way. They'll appeal adverse rulings. They'll claim that producing privilege logs would itself reveal privileged information. They'll argue that national security concerns justify withholding certain documents. They'll do everything they can to delay and obstruct full disclosure. But here's what gives me some hope. Federal judges take congressional mandates seriously, especially when the statute is as clear as the Epstein Transparency Act. If the Trump DOJ can't provide legitimate legal justification for withholding documents, if their privilege claims are as flimsy as they appear to be, judges will order disclosure. And unlike congressional subpoenas, which can be ignored with political impunity, court orders carry real consequences. Defying a federal judge's order can result in contempt sanctions, fines, and even imprisonment for the officials responsible. Congress also has a role to play here. The Epstein Transparency Act is their law. If the executive branch is violating it, Congress has the authority and the responsibility to hold the administration accountable. House and Senate committees could demand testimony from DOJ officials about why documents are being withheld. They could threaten to hold officials in contempt. They could pass additional legislation specifically prohibiting the privilege claims the Trump DOJ is making. Whether Congress will actually do that depends on political will. Democrats will almost certainly push for accountability. But if Republicans control one or both chambers and decide to protect Trump, congressional oversight will be limited. That's the unfortunate reality of our polarized political system. Oversight often depends more on partisan control than on principle. The worst-case scenario is that the Trump administration successfully withholds the documents indefinitely. They drag out litigation until the courts become backlogged, the public loses interest, or Trump leaves office and his successor decides whether to continue the cover-up or release the files. In that scenario, the truth about Epstein's connections to powerful people remains hidden, accountability is avoided, and the Epstein Transparency Act becomes a failed experiment in mandated disclosure. The best-case scenario is that federal judges move quickly to reject the Trump DOJ's privilege claims, order immediate disclosure of the withheld documents, and impose meaningful sanctions if the DOJ refuses to comply. In that scenario, the full truth comes out, whoever it implicates, whatever it reveals. Justice for Epstein's victims includes public accountability for everyone who enabled, protected, or participated in his crimes. Here's what makes this fight over the Epstein files so critical. This is about more than one criminal case or one cover-up. This is about whether powerful people can commit horrific crimes, evade accountability, and use their connections to government to keep the truth hidden. Jeffrey Epstein trafficked underage girls. He ran a sex abuse operation that victimized dozens, if not hundreds, of young women. He did this for decades, and he did it with connections to some of the most powerful people in the world. How was that possible? How did he avoid serious prosecution for so long? Who knew what he was doing? Who benefited from his crimes? Who helped him? Who looked the other way? Those questions deserve answers. The victims and survivors deserve answers. The American people deserve answers. And the Epstein Transparency Act was supposed to ensure that those answers would finally be provided. But if the Trump administration can withhold half the files, if they can claim privileges that the law doesn't authorize and hide the most significant documents, then those questions remain unanswered. The truth remains hidden, and the people who should be held accountable remain protected. This isn't a partisan issue. This isn't about defending or attacking Trump. This is about demanding transparency and accountability when it comes to one of the most disturbing criminal cases in modern American history. If you care about justice for victims of sexual abuse, you should demand full disclosure of the Epstein files. If you care about government accountability, you should demand that federal agencies comply with federal law. If you care about ending elite impunity, you should demand that everyone connected to Epstein, regardless of their politics, their wealth, or their power, be exposed and held accountable. The Trump administration released 3 million documents from the Epstein files on Friday. That's the headline. That's what they want you to remember. But 3 million more documents are still being withheld, hidden behind fraudulent privilege claims, concealed in violation of federal law, protected because the truth they contain is too dangerous for powerful people to allow it to be revealed. Don't fall for the smoke and mirrors. Don't accept the partial release as sufficient. Don't let the Trump administration declare victory for transparency when they're actively engaging in a cover-up. The Epstein Transparency Act is clear. Release everything, protect the victims. The Trump DOJ is violating that law. They're withholding the most significant documents. They're using legal privileges that don't apply. and they're betting that you won't notice or won't care. But this story isn't over. Legal challenges are coming. Federal judges will review the privilege claims, advocates will fight for full disclosure, and the truth, all of it, will eventually come out. Stay informed. Demand accountability. Don't let this story disappear from the headlines just because the administration released some documents while hiding the rest. The next move will be critical. The fight for the full truth about Jeffrey Epstein and everyone connected to him is just beginning. And what's in those 3 million withheld documents could change everything we think we know about power, corruption, and accountability in America. The truth is still hidden, but it won't stay hidden forever.